morning, everyone, and thank you for joining us today. My name is Michaela Vrazdova-Romeser, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time and talk about the H-1B visa and the H-1B registration process. A few housekeeping items before we get started. So some of you may know that the firm Scott Legal PC was founded on an E-2 visa several years ago, and our founder, Ian Scott, is currently in the US on an E-2 visa and has been on several different visas, including the F1, TN, B, and H-1B visa. And as such, we know what you are going through. The firm is a full-service immigration law firm, and we offer immigration services in a number of different areas, including E2, E1, TN, L1, H-1B, family immigration, national interest waivers, EB-5, and extraordinary ability visas, and more. We'll continue to have this webinar series, and we will do at least 2 webinars a week on different immigration topics. At the end of this webinar, we'll send you out some useful tools. So we'll send you the PowerPoint we'll be using today. We'll also send you a link where you can download our guides that go through the visa options in more detail. We'll also send you a link where you can sign up for the additional webinars we'll have in the future. And this webinar is being recorded and will be available on our YouTube channel. We'll also send you a link for our YouTube channel, and we encourage you to subscribe and hit the notification button as we regularly upload new immigration videos. We'll also send you a link where you can set up a consultation with one of our experienced immigration attorneys in case you would like to discuss your case in more detail. So regarding speakers, we are lucky to have Kelly Legrand-Wiener. Kelly is a partner at Scott Legal PC, and she has a vast experience processing H-1B visas. Finally, if you have any questions as we go through the presentation, please feel free to put it in the chat box or in the Q&A box, and we'll get to all questions at the end of the presentation. So without a further delay, let us get started with the PowerPoint presentation. So what is an H-1B visa? So the H-1B visa is a non-immigrant visa that allows you to come to the US and that allows you to work and live in the US. It is a non-immigrant visa, meaning it's not a green card. There is a limit, time limit for which you can get the H-1B visa for. So normally the H-1B is granted in 3-year increments. So you can initially get it for 3 years, and then you can renew it for additional 3 years. And then there are situations, if you have a green card, for example, pending, you could potentially extend the H-1B status. So what are the H-1B visa requirements? So the H-1B worker, to qualify for an H-1B visa, the H-1B worker has to have one of the following. So you don't have to meet all of these. You just have to meet one. So you either have to have a US bachelor's or higher degree that is required by the specific occupation, or you can have a foreign degree that is equivalent to a US bachelor's degree. Now, here, for anyone that has a foreign bachelor's degree, you will need to get this evaluated before submitting your H-1B visa application. And the credentials evaluation would have to confirm that your foreign bachelor's degree is equivalent to at least a US bachelor's degree. If you don't have a US bachelor's degree or a foreign bachelor's degree, you could still qualify for an H-1B visa if you have an unrestricted state license, registration, or a certification that authorizes you to fully practice in the specialty occupation, or if you have some sort of combination of education, training, and progressively responsible experience in the particular specialty, you could qualify for an H-1B visa based on that. And generally, the equivalency is that for, like one 1 year of study is equivalent to 3 years of work experience. So let's say that you never studied and you only have work experience. You would have to have at least 12 years of progressive work experience for you to be able to qualify for an H-1B visa based on that work experience. Next important requirement is that you must have a job offer from a U.S. employer. So, to qualify for an H-1B visa, you cannot just apply for an H-1B visa and say that, you have a bachelor's degree and, you plan to look for a job in the U.S. You have to have a company in the U.S. that is willing to sponsor you, for an H-1B visa. So the next requirement is that the position you are being offered in the US is a specialty occupation. So what does this mean? So the specialty occupation means, and again, you just have to meet one of the following. You don't need to meet all of them. So it generally means that a bachelor's degree or higher or its equivalent is normally the minimum requirement for entry into that particular position. The next way to kind of meet this requirement would be to show that the degree requirement is common to the industry in parallel positions. So some ways to show this would be, for example, to show like LinkedIn posting or, like Glassdoor job postings that would, confirm that for that particular position, other employers generally require a bachelor's degree in a particular field. The next way how you could meet this requirement is to show that the employer that is sponsoring you for the H-1B visa normally requires a degree or its equivalent. So here, how this would generally be shown, the employer would have to submit evidence that in the past, they hired people and they required that people have a degree or its equivalent for this position. And then the last way how you could meet this requirement is to show that the nature of the job or the nature of the specific duties are so specialized and complex that generally only a person who has a bachelor's degree or higher is able to perform the duties. But again, you would just need to meet one of these, not all of them. Perfect. So now let's discuss a little bit more the process, when you can apply for an H-1B visa. So there is a limited number of new H-1B petitions that can be adjudicated each year, and this is called an H-1B cap. So each financial year, 65,000 regular cap petitions can be adjudicated by USCIS, and there are 20,000 so-called master cap petitions that can be adjudicated each year by USCIS. So the 20,000 is reserved for people who have a US master's degree. So you would have to have a master's degree from a US university to be able to fall under this cap, and then the 65,000 is kind of reserved for everyone else. Now, every year more than 85,000 people want to apply for the H-1B visa. So the government has to run what is called an H-1B lottery. And the H-1B lottery is basically kind of like a random computer selection where, like all the H-1B, the US companies submit H-1B registrations on behalf of the prospective employees. Then the government kind of runs the lottery and then randomly selects the 85,000 people who are selected in the lottery. The selection in the lottery doesn't mean that you will automatically get the H-1B visa. It just means that the company then has the opportunity to file the H-1B petition, and then the government then makes a final decision whether they are approving the petition. Now, the cap, the 85,000, that only applies to new H-1B petitions. So, let's say that you were selected in the lottery in the past, like 3 years ago, and now the employer just wants to renew your H-1B visa. You don't have to go through the lottery process again. They can just file an H-1B extension petition, and you wouldn't have to go through the lottery process for extension. Now, let's say that you are changing employers in the US, like let's say that you were selected in the lottery last year, and now you find another job in the US, and then the new company, wants to sponsor you for an H-1B visa. They wouldn't have to go through the lottery process either. They would just have to file an H-1B change of employer petition, and that would have to be approved by the government, but they wouldn't have to go through the lottery process. And as we said, more than 85,000 registrations are submitted each year. So that's why the government has to run an H-1B lottery. And the H-1B lottery is run every year in March. And just to kind of give you an idea, like last year, over 700,000 H-1B registrations were submitted, and there are only 85,000 slots. So you can see that many more people apply than there are kind of slots available. So how does the H-1B lottery works? So as we said, it's a computer-generated random selection process. So in the past, the procedure used to be different. So in the past, all employers that were interested to sponsor new employees for the H-1B visa had to submit the entire H-1B petition to the government, like had to mail a physical copy, and then the government would kind of do the lottery like out of the, like the physical copy submitted. But in 2020, the system kind of changed and the system became electronic. So now what the employers have to do, they just have to submit an H-1B registration online. The H-1B registration asks certain information about the employer and then certain information about the employee. So for the employer, the H-1B registration asks for information like name of the company, DBA, address, like who is signing the form. And then for the employee, they are asking for information such as name, passport number, and then they're asking whether or not you are filing the petition, whether you're filing it under the regular cap or whether you are filing it under the master's cap. But it's usually kind of like a very simplified version of the entire H-1B petition. And then if your registration is selected in the lottery, then you would have to submit the H-1B petition that would have kind of like more information, about the job, about the employer's degree and things like that. But in the H-1B registration, you wouldn't even be kind of submitting any supporting documents like the employee's degree and things like that. It's just kind of like a simplified form that asks for, certain information from the employer and the employee. There are certain employers that do not have to go through the H-1B lottery process, which means that they can sponsor an employee for an H-1B visa at any time. So this is a huge advantage. So what employers, fall under this exemption, and these are called H-1B cap exempt employers. So these would be generally institutions of higher education or related or affiliated nonprofit entities, or it would be nonprofit organizations or government research organizations. So, generally the employers, like they would know if they fall like under one of these exemption. But, if you are looking for a job and you find a job, you are offered a job from one of these employers, the huge advantage of that is that, let's say you find a job in September, October, they can sponsor you for the H-1B visa right away, and they don't have to go through the H-1B lottery process. And then another kind of big advantage, and what, kind of like many H-1B employees take advantage of is that once you have and once you kind of work for an H-1B cap exempt employer, you can get a concurrent employment for a H-1B cap employer. So like, let's say that you are working for a nonprofit, organization that is a cap exempt employer. You are working there full time, 40 hours a week. But you also find a job, let's say 10 hours a week for kind of like a private company that would normally have to go through the H-1B lottery process. You could accept the employment, the 10 hours a week employment for the private company, and the advantage of that is that the private company, they wouldn't have to go through the H-1B lottery process. So this is one thing, like many of the employees that work for cap exempt entities, they take advantage of. Perfect. So now let's discuss, how the H-1B kind of registration and H-1B lottery process works. So every year, the H-1B lottery, the registration period opens in March. This year, it's opening on March 7, which is Friday, and then it closes on March 24. The U.S. employers will have over 2 weeks to kind of submit the H-1B registration for, employees they want to, they would be willing to sponsor. So, after the H-1B registration period closes on March 24, after that, USCIS is going to run the lottery, and then they are planning to inform all the selected applicants by March 31st, 2025. So if you are an employer, you should know by March 31st whether or not your H-1B registration was selected. If it was selected, the U.S. employers will then have 90 days to file the actual H-1B petition with the government. So last year, the period, and usually the period when you can file runs from April 1st up until June 30. And in this window, you have to submit the H-1B petition to the government, and it has to be received by the government within this window. So how can an H-1B employer kind of submit an H-1B registration? So the employers have to create an online USCIS account. And, this is the case. The employers have to create an account, like in case they want to submit the registration themselves, but also, like if they have an attorney, who will be filing the registration on their behalf, they still have to make the USCIS account, because how it works in that case is that the attorney will kind of prepare, the registration and all the forms, and then we'll electronically kind of like send it to the employer for the review. The employer is going to log into the system, just review the H-1B registration. If everything looks good, they're just going to sign it, and then the attorney is going to submit the H-1B registration and pay the fee. In case the H-1B employer wants to just submit the registration, by themselves, that's fine as well. But in that case, they would have to kind of prepare the H-1B registration through their portal, sign it, and then pay the H-1B registration fee. So what type of documents, you have to submit? Like if your H-1B registration is selected, what type of documents you have to submit? So in the beginning of process, you should file if your H-1B registration is selected and you are notified that you can submit an H-1B petition, you should then file a labor condition application with the Department of Labor. This is a form that is submitted to the Department of Labor, and it has certain information, again, about the employer, and just kind of like more importantly about the location where the employee will be working. It has information about kind of like the job, the employee will be working, and about the wage because what the purpose of the form is that the Department of Labor wants to make sure, you know, that the employer will pay kind of the required prevailing wage to the employee. And, you know, like if you have an attorney, like the attorney would kind of assist you with filing this form. So there is one document, you know, then you would have to submit the employee's kind of documents showing that the employee meets the H-1B requirement. And this would be kind of the evidence that the employee either has a bachelor's degree or equivalent to bachelor's degree. If the registration was filed under the master's cap, then you would have to submit evidence that the employee has a U.S. master's. And so generally you would be submitting evidence of the employee's kind of education. So that would be diploma, transcripts, and then, you know, things like passport. And then if you are filing the petition as a change of status petition within, you know, so that would be the case. Change of status petition would be only possible if the H-1B employee is currently in the U.S. On some other non-immigrant status. So that way the petition could be filed as change of status. If the employee is currently outside the U.S., the employee would have to apply kind of like for an H-1B visa at the consulate. But applying for an H-1B visa at a consulate would only be possible after the H-1B petition would be approved by USCIS. And some other documents you would have to submit as part of the H-1B petition would be one of the kind of most important documents would be an H-1B employment letter, in which you would be describing, you know, like what does your company do, and then it would have kind of detailed information about the job you are offering to the employee. So it should have, you know, things like job title, you know, like what salary do you plan to pay to the employee, and then kind of detailed job duties, kind of describing what type of job the employee will be performing in the U.S. And just a quick note, like in both cases, like if the petition is filed as a change of status or if it's filed as consular processing, in both cases, the earliest possible start date for the H-1B employee would be October 1st. So, you know, let's say that the employer files a registration this March, the petition is, you know, is selected and then is approved. You know, you could, the H-1B kind of, you could only start working on the H-1B status as of October 1st. So if you are already in the US on some other status, like let's say F1 OPT, there are some rules that would allow you to kind of possibly maintain the F1 OPT status up until October 1st. But let's say that you are, or the employee is outside the US, the employer filed the petition, and let's say that the petition is approved in May or June, the earliest possible start date would still be October 1st. Perfect. So now let's discuss, you know, if the H-1B employee's family could come to the U.S. and who could potentially come to the U.S. So the H-1B employee's spouse and then children who are unmarried and under the age of 21 could come to the U.S. So both, you know, your children and spouse can study in the U.S., but unfortunately, the H-4 spouses generally cannot work in the U.S. Unless they meet one of these exceptions. So the first exception would be that, you know, the H-1B employee has an approved I-140 petition, which is kind of like an immigrant petition filed by the employer. And the second, the second exception would be if there is if a perm application, if the labor condition application or the I-140 petition were filed at least 365 days before your 6-year H-1B period is up. So there are kind of like two narrow exceptions, and both of them would only kind of be applicable, you know, like if you have like an H-1B employer who is sponsoring you for a green card. Perfect. And now I will turn it over to Kelly, and she will go over the H-1B fees.
Thank you, Michaela. So one question we get a lot is kind of who can pay for the fees related to the H-1B. And it is important to pay attention to this because there's some fees that only the H-1B employer is allowed to pay. So generally, the employers cannot require that an employee pay for or reimburse the employer for these attorney's fees that are associated with an H-1B visa. You're also, it's not allowed to have kind of side agreements that say, well, we'll pay it up front and the employee will have to pay it back. And additionally, employers can't take the fees out of the employee's paycheck, although there are some limited exceptions to this, depending on, whether or not the deduction drops the employee's wage below kind of the required prevailing wage that is being paid. However, those exceptions are very limited, and something you should definitely discuss with an attorney before taking any action on that. There is an exception to this where the H-1B employee can pay the legal fees that are related to their spouse and their children. So any dependent fees can be paid by the employee as opposed to the employer. Um, the government filing fees, there are high fees for the H-1B. There's a fee for filing Form I-129. There's an anti-fraud filing fee. There's an American Competitive Workforce Act fee. There's an additional very high fee for companies that are larger, so 50 employees or more, where you have a high percentage of H or L employees. And the employer is required to pay these filing fees. However, if the employee wants to premium process the case, so pay an additional fee to get a faster response, they are permitted to pay that. The employer could also pay it, but that's the one fee that the employee could pay if they prefer. All right. So what happens if I lose my H-1B job? So years ago, it was the case that if you lost your job, there was no grace period, and it was quite difficult. You basically had to leave almost immediately, or any grace period was, very. It wasn't official. Maybe it was something that they kind of sometimes would add, sometimes not. This was changed in the regulations and the grace periods, which we'll talk more about in the next slide, are more official now. The important thing here is that if you are laid off unexpectedly, or let's say you quit your job, sooner than planned, you do have this 60-day grace period, although it could be shorter depending on when your I-94 expires. So if you do get laid off, the first thing you want to do is check your I-94 and make sure, see when that ends. So if the I-94 expires, 15 days from the day you're laid off, that's when your grace period is going to end. If it's, 2 years later, then you're going to have the full 60-day grace period. So during this time, there's a few things you can do. One is you can just kind of make your plans to depart the United States. Another is that you can look for a new job. If, let's say, you find a new H-1B employer, they could file a change of employer petition for you, to get a new H-1B. You could also change to a different visa status. So let's say if you are here and you're on an H-1B and your spouse is also on an H-1B, you could transfer to H-4 dependent status. If you plan to go back to school, you could transfer to F-1, or if you just need some more time, or maybe you want to do some tourist activities in the U.S., you could transfer to a B visa. The important thing is that if you're going to do a change of status, or a change of employer to H-1B, that has to be filed within that 60-day grace period. So if you're outside that 60-day grace period, or, the grace period's expired, you need to leave the US, and you would need to kind of get that new visa abroad before you could come back. All right, let's talk a little bit more about the grace periods. These were added, to the regulations, in 2017, and are kind of a great, benefit to visa holders to give them kind of this extra time. So there's two grace periods. So one is the 60-day grace period. So this is when employment ends prior to the end of your planned validity period, and this can be, again, you get laid off or you, proactively quit. It's relatively open in that way. Um, One thing is that this is a discretionary grace period, so Department of Homeland Security does technically have the ability to eliminate or shorten this 60-day period. We haven't seen them use this, but just something to keep in mind. And you also cannot work during the grace period. So, let's say that you were, maybe switching to, E2 investor status and you want to just start up, a business, you can't start working there until you actually get the approval for whatever the new work authorized status is. Um, 10-day grace periods were also added to the regulations in 2017. This kind of codifies that you can be granted an additional period of 10 days before and after your validity period, on your approval. So very often, if you're entering the United States, with your H-1B visa stamp, and then you check your electronic I-94 after you enter, you may see 10 days added, to the end of your validity period, and that is that 10-day grace period. You cannot work during the 10-day grace period, but it's there to kind of give you an ability to, kind of make your plans to kind of pack up and leave the United States or whatever you're going to do, prior to leaving the U.S. after the validity period for your visa ends. All right, let's talk about how many times you can renew your H-1B visa. So the H-1B can be granted in 3-year increments for up to 6 years total. After the 6 years, you would need to, either kind of have another visa status or leave the United States. Um, Only the time that you physically spend in the US counts towards the 6 years, though. So sometimes if people are traveling a lot for business, or they're in and out, maybe they spend a few months abroad, you can file what's called an H-1B recapture petition, and kind of prove your travel history. And this can give you additional time. So it's always a good idea to save things like your flights, any proof that you departed the United States, any proof of when you were outside the U.S., especially as they've started to do away with kind of the physical stamps in the passports. You really want to have that evidence either both on your I-94 travel history, which will be there electronically, but sometimes there are mistakes on that, so you want to have your own evidence as well, to prove any times you spent outside the United States, because those can be recaptured, to extend your H-1B. There's also some exceptions in the law that allow people to extend their H-1B beyond 6 years when they're in the green card process. So one is called the lengthy adjudication delay. So this is where you can get 1-year H-1B extensions beyond the 6 years based on the timing of the filing of either a labor certification with the Department of Labor or filing an immigrant visa petition with USCIS. So if 365 days have passed since either of those filings and they have not been, kind of denied or, any approvals revoked, you can get those H-1B extensions based on that. There's also a per country limit exemption. So this is where maybe you get to the end of the process, you have, an approved I-140, but you cannot file for your green card yet because there's not a green card available in your category. And so for these applicants, what they can do is file with a copy of the visa bulletin and a copy of their approved I-140 with their priority date showing that they cannot file yet for their green card, and you can get extensions of the H-1B in 3-year increments. So this is a good benefit that's offered, to H-1B visa holders. Right now, there's backlogs, significant backlogs in EB2 and EB3 for Indian and Chinese nationals, or people born in India and China, rather. And there's also worldwide backlogs in these categories now. So this has become very relevant, to all people on H-1Bs who are in the green card process. All right. Do you need an H-1B to apply for a green card? So sometimes people have the impression that there's kind of a system where you need to first get an H-1B and then you can get a green card. And that's not the case. You don't need to be on an H-1B to apply for a green card. That being said, there are some benefits when you're on an H-1B. So this is why people may want to switch to an H-1B. For example, if they're working on a TN, sometimes if they want to go through the green card process, they want to switch to an H-1B. One major reason for this is that the H-1B allows for dual intent. So there's many visa types where you have to prove you don't have immigrant intent, you don't intend to stay in the United States permanently, you intend to depart, you have a residence abroad. The H-1B specifically says it's okay for you to be on this temporary visa, but also have the intent to file a green card petition and remain in the United States permanently. So, that's a big benefit to that visa type. Additionally, when the green card application is filed, if you're doing an adjustment of status in the United States, you file a form called an I-485. And once that's filed, you cannot travel outside the United States without abandoning your green card application. You can file for travel authorization, but these are taking, several months, even up to or over a year to be approved. The H-1B gives a benefit here because if you do have a valid H-1B visa stamp and you're, coming back in to work for the same employer, you can just travel on the H-1B visa stamp. You don't actually have to wait for the travel authorization, even when you have an adjustment of status pending. So that is a large benefit that many people don't have during the green card process. And then another benefit to the H-1B is that, if your immigrant visa category is backlogged, there is this process for extending the H-1B status while you wait. So as I discussed in the last slide, you can kind of continue to extend in increments of 1 year or 3 years while you're going through that green card process. There's other visas, like, for example, the L, where you kind of are going to max out at either 7 years or 5 years, and then you can't extend beyond it. So the H-1B does have that benefit, during the green card process. All right. So, what is the green card process? Going from an H-1B to a green card, and we're going to talk here about kind of the most common route, which is to go through the EB-2 or EB-3 process with a perm, which is where a U.S. employer is going to sponsor you for a green card. So, while you're on your H-1B, your employer can choose to sponsor you. It's not the only way, and we do have other presentations that kind of talk about other green card options. But for the purposes of this presentation, we're going to kind of focus on the perm process, which is most common in this scenario. The perm process is where the U.S. employer is going to test the U.S. labor market to determine if there's any willing, qualified, and available U.S. workers for the job that they're sponsoring the employee for. So that's kind of they draft the job description, they get a prevailing wage determination that says how much they have to pay, once the green card is granted. Then they test the labor market. If they do not find any willing, qualified, and available U.S. workers, they'll go ahead and file the labor certification with the Department of Labor. That whole process that I just described is kind of taking, a couple years. It can take about 6 to 9 months to get the prevailing wage determination. It's taking about 15 months for the Department of Labor to review labor certifications. And then the labor market test itself is about 3 months. So within that, it can be quite a lengthy process right now due to just very long processing times. Once the labor certification is approved, the employer then files Form I-140 with U.S. Citizenship and Immigration Services. They have to include proof that they have the ability to pay the prevailing wage, and also proof that the employee meets all the requirements for the job. Degree, any transcripts, any proof of the skills or employer experience that are outlined in the perm. The employee has to show they meet all of those. If a visa is available, so if the visa bulletin shows that the priority date is current, then the employee can also apply for a green card. They can either do an adjustment of status with U.S. Citizenship and Immigration Services from within the United States, or they can apply for the green card at a U.S. consulate abroad through the consular processing process, and that involves the National Visa Center as well. So this is kind of again, like, not the only process you can go through to get your green card from an H-1B. There are certainly others, and we do talk about those in other presentations. All right. Do you have to prove the company cannot find U.S. workers? So I think because this is a requirement for the perm green card process, sometimes people assume it is also a requirement for the H-1B, and it's not the case for the majority of H-1B employers. There are very specific H-1B employers, so H-1B dependent employers, meaning company of over 50 who has, over 50% of people on, H's or L's. Or willful violators, so people who violated the compliance requirements of the program, and they must attest they will not displace U.S. workers and take steps to recruit for U.S. workers before filling an H-1B petition. But for the vast majority of people employers applying for H-1Bs, they do not need to take, these steps. Testing the labor market is part of the perm green card process, but is, again, not a requirement for most H-1B employers. All right, so we've reached the end of the presentation. Let's see. So there's a question here, Michaela. It says, does that mean only 20,000 master's or PhD holders will be selected and 65,000 with undergrad will be selected? Um, so do you want to take this one? I think you're still muted.
Sorry. Yeah, so 65,000 of the, out of the registration is reserved for people, for everyone. And then there is people who have a US master's, then they can apply in the 20,000 lottery. So yeah.
Yeah, so it doesn't mean that kind of 65,000 people with undergrad degrees will be selected because as Michaela mentioned, people who have master's degree or higher are kind of uh, uh, included in both rounds of selection. So there could be some people with having a master's degree or higher, US master's degree or higher does have that benefit that you get kind of two chances at the lottery. All right. So I think we don't have any more questions. So I think we'll close here. Thank you everyone for joining. Thank you, Michaela, for sharing your knowledge. I hope everyone has a wonderful day.